Our next case will be Barnes versus Benny's Bar. Okay, who will be arguing for the appellants? Okay. Then you can go ahead and stand at the podium. Can you see the clock right in front of you? That tells you how much time you have. You have the opportunity to argue at first. They then have the opportunity to respond, and then you can save a little bit of your time for rebuttal. You have 20 minutes total. How do you want to divide that 20 minutes up?
I'd like to preserve 5 minutes for rebuttal.
Okay. All right, and also, just to advise you, this is not a place where we take testimony or any witness testimony. We have to rely on what is in the record before us in deciding whether there is an error or not. Okay?
Correct.
Okay, you can go ahead and proceed with your argument. And first, go ahead and state your name, though.
Melanie Barnes,
right,
appearing pro se.
All right, go ahead.
May it please the court. On page 869 of the record, summary judgment, count 2 damages. The Barnes were denied their due process. The Barnes were denied, it states right on there, false invoices. And so the Barnes were denied the right to freedom of speech, which is under the Constitution of the United States, Amendment 1, freedom of speech. They were denied the right to submit truthful evidence to the courts to prove that the invoices were fraudulent and falsified.
Okay, are you saying this because the judge granted summary judgment and you didn't have a trial? Is that your argument?
Correct. We actually had submitted for a trial and also demanded a trial, which we never received. The contract in question, dated May 2nd of 2012, actually has grace periods in it, and by Florida law, it states that the tenant has a right to give a grace period. The contract does have a 5-day grace period. It has 10-day grace periods.
But that grace period was in the lease agreement, but what you were addressing at the time was a court order that required monies to be placed into the registry of the court. That wasn't the contract, it was a court order. Do you understand?
Right, yes, it was court ordered to put money into
And the court order didn't provide for grace period.
Well, under the Constitution of the United States with the freedom to contract, I don't believe that the contract should have been changed in any way.
Wasn't at that point, wasn't there a dispute as far as the contract and you're not abiding by the lease at that point? That's kind of why the trial judge made that ruling, correct?
Well, the appealee stated that they did not give a grace period in the contract. And according to the law, a grace period would be until you are penalized.
Okay, but the judge is proceeding under statute and said when the parties are arguing over the contract like you are and the tenant has stopped paying rent because of the argument that the court can order money be paid in the court registry. And the statute covers this situation and says that you then have to pay by the order set, by the date set in the order, and that if it's not paid by that date, the judge can enter a default. I mean, that's what the legislature has said in trying to balance the rights of the tenant landlord when they're having a contract dispute like you all were.
Correct. Our whole dispute was we were actually buying the property. Appealee state we were managing the properties. The two properties consisted of, the property in front was
But
actually,
that argument was one rejected by the trial court and found that it was a lease agreement, not a contract for purchase. Correct?
they've never had evidentiary hearing to determine if it was a mortgage or lease.
Did you have a mortgage on the property? Was there a mortgage? Was there a deed?
Well, what it was is we had 10 years to pay. We were paying $2,500 a month for 10 years. And it says there's an option of $1, but of course, nobody's going to be able to purchase, commercial property for $1. But, so we did our own repairs and everything to the properties.
That was pursuant to the lease agreement, correct? Did the lease require that you all were the ones that would maintain the property?
Correct. Actually, when the...
So that doesn't make it a contract for purchase, does it?
I'm sorry?
That doesn't make it a contract for purchase because you've contracted under the lease to do the repairs.
Well, my position, Your Honor, is that we were doing the repairs, and we didn't contract with the Appeals to be managers of the property. It was actually for a purchase of those two properties. And we went for a summary judgment trying to state that this was actually in the wrong courts. That under 8342, the legislators set a bright line for distinguishing tenants from buyers. And they said that when you have a remedy or when you have equity in property, that eviction is not the proper process. And our fight is that we did all the repairs and put out all of our money, paid the taxes, which was in the contract. But then when it came down to the time for them to make them abide by the contract of giving us the grace period, it was denied. So it's kind of like it worked one way and not the other.
Under the lease, when was the earliest time that you could exercise your option to purchase?
In 10 years.
Okay. So you never exercised an option to purchase?
Well, we hadn't had it 10 years. It was set up for $2,500 a month for 10 years. And at the end, we could pay the $1 and it was ours. Yeah. My argument is we have equity in that property. The appeals are stating that we were ordered by the court to make the repairs, which there actually is no order in the court.
Now, did you all want them to reduce the monthly obligation you had after the damage to the bar?
They offered that up front. We never agreed with it.
Okay. But you didn't pay the $2,500, you paid the lesser amount.
Yes, we did.
Okay.
Yes.
Now, if you were buying the property, that wouldn't be affected. You'd still have the $2,500 a month obligation. But if you're paying rent and the rent got reduced while the premises were damaged, that would be consistent with the lease. Would you agree with that?
Okay, I didn't quite understand what was the question. Sorry.
Well, you want us to say that this was a purchase agreement, not a lease. But if it was a purchase agreement, there wouldn't be any reduction when there was a damage to the bar.
Correct. I agree with that.
Okay, but you all, for an extended period of time, only were paying $1,700 a month rather than $2,500 a month.
Correct. Actually, in the contract, it did specify that the main reason for us getting those properties was to have that bar being running at all points of time. And due to the...
Right, but if you're buying it, it doesn't matter if it's a bar or whatever it is. I mean, if you're buying it, it's your property.
Correct. So actually, in our contract, it does state we were supposed to make the repairs. But under the Florida statutes, if it was a lease, according to the safety and habituality of the building, then it would be under the appeals to fix it. Actually, during this whole case, it started out with notices that had been incorrect from when I first started getting notices from the appealees. According to the contract, the days were reduced in time. It was not even going by the contract. And anyway, what I'd like to say is that under the Constitution of the United States, under the 5th and 14th Amendment, everybody's required due process law. And we believe that our due process law was denied when we did not get a chance to speak at the county damages summary judgment. There's fraud in the invoices that are submitted. I'm being charged for taxes. The receipt states right in where they filed it, it was paid by myself. I'm being charged with invoices that are, some of them are almost a year after they had possession of the bar back.
Did you have insurance on the property?
No. Actually, in the beginning, the appealee told me he did, only to find out that it was the driver that ran through the building, it was his insurance that paid for it, for the repairs. Now, we did make the repairs, and the appealees actually had hired their own contractor, and they came to us to do the repairs. Well, what had ended up happening is we did the majority of the repairs, and they got the money for it. There's no paperwork showing. I had requested.
Did you receive a payment for business interruption from an insurance company?
No, sir.
Okay.
So under the United States Constitution, I know fraud voids a summary judgment. Also, a lack of due process voids all orders and summary judgments of the court. And we were denied due process. The only witness they would let speak was Mr. Donsky, the attorney for Nationwide. And during this whole case, the appealee had constant contact with that attorney.
Did you file affidavits in opposition to the summary judgment?
Your Honor, I was.
It's kind of a yes or no answer.
Oh, I'm sorry. Did I file affidavits?
Were there affidavits filed in opposition to summary judgment?
I couldn't tell you, Your Honor.
I think under the record, as I've seen it, the answer to that is no, that there weren't. Because what we do is we're a court of correction of error. We don't decide cases just saying, well, if we were the trial court, this is how we would decide the case. We look to see whether the trial court committed reversible error in cases, and if so, we correct that reversible error. So the trial judge was looking at the rules of civil procedure, because that's what the trial judge is required to do. And the rules of civil procedure that you were bound by below state that if there's a motion for summary judgment, if you disagree with the assertions, the factual assertions in the motion for summary judgment, it gives you a specific time frame with which to file affidavits in opposition to that motion for summary judgment. And if that isn't done, then the judge simply looks at what's in front of him or her at the time of summary judgment, and it appears in this case that that's what the trial judge might have done. And so I'm trying to understand where the judge committed legal error in doing that under the rules of civil procedure.
Well, the errors would be one, there's fraud. That's, I mean.
Well, but then you file affidavits establishing that there's fraud.
No, I did not. I found out all this fraud after I did have an attorney, and after my attorney quit, I didn't have any of the paperwork. He wouldn't release my paperwork to me. So,
Again, what we have to look at is what did the trial judge have before he or she? And
I'm
so
sorry.
we have to look at what the trial judge was facing when he made a ruling. That's what our role is. And so it doesn't appear that if you make this claim of fraud, that you put it in any form for the trial judge to review at the time that the trial judge issued a ruling upon the motion for summary judgment.
I didn't find out about half of this fraud until afterwards. I did, when I went to the summary judgment hearing, I did bring up the false invoices, and I was trying.
But you have to have done that prior to the summary judgment hearing under the rules of civil procedure. You can't come into the hearing and present evidence because that's prohibited by the rules of civil procedure.
Correct. Where there's fraud involved, it can be brought up first time on appeal, and I was denied due process and the right to submit evidence of fraud. It's, how can I be charged for stuff I've already paid, and how can I be charged for stuff that is procured after they already had possession of the place, like almost a year later?
But weren't these things that were known to you at the time of the summary judgment? Couldn't they have been known to you? I mean, you knew at that point what you had paid and what you hadn't paid.
I just saw the invoices and stuff when I, no, I didn't know, Your Honor, I didn't know all this fraud was involved until I started investigating.
Okay, but their motion for summary judgment, they said this much money is owed, and then they attached sworn statements as to why they were saying that much money is owed. Now you would have had that at least 20 days before the hearing under the rules.
I didn't receive 20 days.
Okay.
I would like to say that our whole initial thing is under the, even under the Internal Revenue Service, they have considered, it doesn't matter if it's stated a lease, it's considered an installment sale, and it's considered a mortgage and has to be foreclosed upon. I have been taxed by the Internal Revenue Service as a sale. So it'd be kind of contradictory if the law's saying it's a rental and I'm being charged by the IRS for a sale.
Okay. Do you want to save the rest of your time for rebuttal, or do you?
Yes, thank you.
All right, thank you.
Thank you.
Good morning. May it please the court. My name is Audrey Hain, and I represent the appellee, Benny's Bar, LLC. I'd like to first address the issue of the lease versus contract for sale. The issue was referenced in their answer to the complaint back in March of 2016, and again a month later they filed the motion for summary judgment on that issue specifically. That motion was heard a month later, and the court issued, actually we don't have an order or a transcript from that hearing. We have the civil court minutes that indicate that that motion was denied. Before that hearing, appellee did file a response, a written response to that motion, as well as an affidavit, and the sole issue was lease versus contract for sale.
So it's a 10-year, they pay $2,500 a month for 10 years, and then they get to purchase it for $1.
As long as they were in full compliance with the agreement and there was no default.
Why isn't that a sale of the property?
When you have well, there are several reasons.
When you lease property, do you typically have a right to purchase it at the end of the lease?
You don't have to, no.
Do you typically?
I don't know that it's typical, but it is certainly an option for the parties to the contract to have that provision. In this case, there was no mortgage.
Your position is that doesn't convert it into a contract for purchase?
Correct.
Why not?
One is there was no, I will point out, as has been referenced, there was no mortgage, there was no deed, there were no doc stamps for recording. The parties,
They hadn't exercised the option at that point.
correct, and pursuant to that buyout provision in the contract, if they were in default of any provision of that agreement, under the case law that's been argued in our answer brief, the buyout option terminates. There was a default in the payment of rent as well as with the payment of property taxes, and those defaults were alleged at the time of the complaint. So with those defaults, by the plain language of that lease agreement, that buyout provision terminated. So in addition to having that one hearing in May of 2016 where the court denied the motion for summary judgment on that sole issue, there was again a subsequent hearing where the parties were there to determine the amount of money to be placed in the court registry. And based on the civil court minutes document in the record, it was also a final hearing on the count for possession. At that hearing, it was a full evidentiary hearing. We had testimony from the nationwide representative, Mr. Donsky, and rather than attempt to revive or re-argue the issue of lease versus contract for sale, the sole issue was whether Benny's Bar was hindering the repairs to the property. So to say that there was no evidentiary hearing is false. Two, by failing to again even set it for a new hearing or argue that issue at that subsequent hearing, they've abandoned the argument. In addition to the fact that it is our position that the court had ruled on it. The court had found that this was a lease agreement.
Well, denying a summary judgment does not mean that the court found it was a lease agreement. All it was doing was finding that they hadn't proved it, made it an issue where there was no material disputed issue of fact.
Correct, and I would agree with that. So then the follow-up argument is, okay, subsequently, a month or two later, there's a full evidentiary hearing. That issue could have actually been raised and set at a different hearing, or even at that hearing that was already being held on a final hearing on the count of possession. That would have been the time to do it. Appellants chose to abandon that issue.
Do they have counsel at that time still?
Yes, sir.
Yeah, okay.
Counsel did not withdraw until August of 2017, which was very near the end of the case. In addition to the abandonment, if the argument had been presented at that subsequent hearing, and we had a transcript of that, our argument is that the case law would indicate that buyout provision did not turn this lease agreement into a sales contract. They were in default. That really hasn't been disagreed with. They failed to pay the rent. They failed to pay the property taxes. By the plain language of that buyout provision, they were in default, and the buyout provision terminated. Subsequent to that evidentiary hearing, we had an order that the court entered, which indicated how much money was to be placed into the registry. That is where the whole 5-day argument came in. And based on appellant's failure to pay the money into the registry, a judgment of possession was subsequently entered. The judgment of possession was entered without hearing. However, based on motions by appellant, 2 hearings were subsequently held where they could argue that we have a 5-day grace period. And extensively, the lower court heard that issue and resolved it against appellant. As has been indicated by your honors, the 5 days in the lease agreement was actually a 5-day period before late charges could be imposed. It was not a grace period. But even so, we had a court order. And that court order is going to prevail, and it provided for money to be deposited by a certain date. Having not been deposited by that date, the judgment for possession was entered. Subsequently, appellant was given additional time to file a second amended complaint and counterclaim. That was ultimately dismissed with prejudice. And then we finally get, a year later, this is supposed to be a summary judgment, a summary eviction proceeding. A year later, after the judgment for possession, we get to the point of a motion for summary judgment filed for the damages. The motion and the affidavits were filed over 3 months before the hearing. So she's correct, she didn't have 20 days. She had over 3 months. And yet at the hearing, there were no opposing affidavits submitted prior to or even at the time, and a motion for continuance was made, and the judge indicated very clearly, you've known about this for 3 months. There was been plenty of time to bring any objections to the motion or to the affidavits prior to that hearing. As a result, the judge did actually enter the final judgment for damages. There was no motion for rehearing, no motion to amend, no motion to correct the final judgment. Should there have been discrepancies or an objection to the monetary damage award. Rather, we have proceeded here to your court, where continuously there is this attempt to rewrite the history of this case and throw mud up against the wall to see what will stick. What will stick in this case that was supposed to be a summary proceeding, a summary eviction proceeding, that we are now over 3 years in. As to any issues, there were certain comments made about the IRS taxing the appellant for this as a contract for sale versus lease. That is the first time that's ever been heard.
It's not in the record.
Okay. And I will comment as well as to the issue of repair, because that has been emphasized, that the repairs were actually done by Benny's Bar. Benny's Bar, the insurance that was paying out was the insurance of the driver who hit the bar nationwide.
Just out of curiosity, I know it's got nothing to do with the issues on this appeal, but was the driver that crashed in the bar, was he related to the bar in terms of had he been served or anything at the bar?
To my knowledge, no. He had not been served at that bar that evening.
Just unlucky.
Unfortunately. Yes. So the repairs were actually done by Benny's Bar. Over $45,000 was obtained by Benny's Bar from Nationwide to make major repairs to the building. He was the property owner. He was the claimant under the policy, and he made the repairs. At the time of the payout of these repairs, Nationwide was trying to resolve as well the claims that appellant would have for any lost profits or the like. But we have no knowledge as to what payments were made to appellant, only that the money that was paid by Nationwide was paid to Benny's Bar, and actually it was paid to the contractors. But Benny's Bar arranged for those repairs to be made.
And how long did those repairs take?
It was less than 6 months, I believe, but it could have been done actually quicker. There was disputes and controversy over appellants allowing the contractors onto the property, as well as the inspectors for the property to be repaired.
Right. But ultimately, does this case come down to the rules of civil procedure?
Yes, it does. Affidavits being filed timely, motions and issues being set for hearing. I think every opportunity was given to appellant to have their day in court, and it was given multiple times. And they were represented by counsel the majority of this case. So with that record before you, that there is no no other option than to affirm the trial court, not only the judgment for possession, but also the judgment for damages. Thank you.
Thank you.
May it please the court?
Ms. Barnes, you have a little under 3.5 minutes left.
Okay, I'd just like to state that Benny's Bar was paid by Nationwide for the repairs. Me and my husband did do most of the repairs. That they have no evidence of just a few invoices. We actually did the repairs ourselves. They actually stated in the record that that the court ordered us to make the repairs. And we did actually make almost all the repairs. So what generally happened is Nationwide did pay Benny's Bar and his contractor for the repairs, and that money apparently was just pocketed, I guess. We spent a lot of our money and our time and labor in repairing the bar, and which was never refunded, any of it to us. I've got outstanding bills and stuff that was never paid by the insurance company. I couldn't get it submitted. The appealees were allowed to talk to Donsky, the Nationwide's attorney, the whole time, and which caused injustice and prejudice against us. Our witnesses were sequestered in the hallway and were never heard. Under the Constitution of the United States, we were denied our freedom of speech. We were denied the right to be heard, the right to submit truthful evidence into the court. And according to the Supreme Court, anytime you're denied freedom of speech, it's automatic reversal.
Thank you.
Thank you.
All right, thank you. All right, we'll be in recess.